Hello everyone, we will discuss about CIAP Document 102, Uniform General Conditions of Contract for Private Construction.
Hello everyone, my name is Ivrahim Palmenco and I'm the first reporter for our group, and I'm here to discuss CIAP Document 102, Section 1, Definition and Documents. Article 1, Definitions. So for the first question, who are the parties involved in a contract for private construction under CIAP Document 102? The parties mainly involved are the owner and his contractor, or in some cases, the contractor and his subcontractor. An owner is the person or entity or authorized representative thereof who signed the contract as owner. He is represented by an owner's representative, who is the person or entity commissioned by the owner or authorized in writing by the owner to act on his behalf. A contractor is the person or firm duly registered and licensed by the Philippine Contractors Accreditation Board, whose bid proposal has been accepted and to whom was awarded the contract to execute the work. And a subcontractor is a contractor duly registered and licensed by the Philippine Contractors Accreditation Board, who signs a construction contract with the main contractor. Next, what is a contract for private construction? A contract is the term used to describe the combination of two sets of documents, the agreement and contract documents. Agreement is the term used to describe the agreement signed by the owner and the contractor, excluding the contract documents, while contract documents are the documents attached to the agreement and then identified therein as contract documents, including all additions, deletions, and modifications incorporated to those contract documents. These generally include the following: special provisions or conditions, general conditions, specifications, drawings, and other bid documents. What is the work that the contractor must perform pursuant to the agreement? Work is all contractor-provided labor and/or materials as well as equipment, transportation, or other facilities necessary to commence and complete construction and to fulfill all his obligations per the contract. The work must be completed within a certain time limit or completion time. In some cases, the owner may issue a written change order to the contractor to authorize changes or variations in the work, whether or not it requires an adjustment in the contract price or contract time. For the fourth question, the CIAP Document 102 provides for a specific bidding process in order for a party to become a contractor. The CIAP Document 102 does not explicitly give a step-by-step process for the bidding. Nevertheless, it defines several prominent terms in relation to the bidding process. An invitation to bid. An invitation to bid is the notice published by the owner or the invitation issued to prospective bidders, giving information as to the nature of the proposed project, conditions for the issuance of contract documents, date of bidding, and information that would give the contractor a general idea of the magnitude and extent of the project. Bid documents collectively refer to all documents provided or made available to prospective bidders, which include the invitation to bid and a copy of the contract, which the winning bidders would be required to sign with the owner, and the contract documents. A bid is the tender or proposal or quotation or offer of a bidder to perform the work described in the contract, while a bid bond serves as a guarantee that the bidder will enter the contract with the owner for the construction of the work if the contract is awarded to them. What are costs as defined under CIAP Document 102, and when a contractor subcontract in order to complete the work under the agreement? Cost means all expenditures properly incurred or to be incurred, whether on or off the site, including overhead and other charges properly allocable thereto, but does not include any allowance for profit. The contractor incurs costs when performing the work. And yes, a contractor may engage a subcontractor to act for or in its behalf in executing any part of the contract. If a party merely furnishes materials without labor, said party is a supplier and not a subcontractor, therefore irrelevant to the agreement. Must the contractor provide any securities to guarantee the performance of the work? Yes, there are three kinds of bonds defined in CIAP Document 102: guarantee bond, payment bond, and performance bond. The contractor and his surety furnish these bonds. A surety is the person, firm, or corporation which issues the bond required of the contractor. Guarantee bond is furnished as a guarantee of the quality of the materials provided, the equipment installed, and the workmanship provided by the contractor. Payment bond is furnished as a guarantee of good faith on the part of the contractor to faithfully comply with the contract in respect of its obligations arising therefrom to its workers, subcontractors, and suppliers. Performance bond is furnished as a guarantee of good faith on the part of the contractor to execute the work in accordance with the contract. Next, generally, what is the amount to be paid by the owner to the contractor for the execution of the work? The owner should pay the contract price, or the amount in money or other consideration to be paid by the owner to the contractor for the execution of the work in accordance with the contract. The owner's obligation to pay the contract price ends when he makes the final payment to the contractor. There is a final payment when payment is made of the final progress, billing, and all approved claims, including but not limited to variations in the work, contract price adjustments and/or escalation, acceleration of work, and others. Finally, what to approve, directed, and acceptable, furnish, install, provide, and necessary mean. Approved, directed, and acceptable. The words approved, directed, and acceptable, or words of like import, shall mean approved, directed by, or acceptable to the owner. Furnish. The word furnish shall be understood to mean purchase and/or fabricate and deliver to the job site or other location when so designated. Install. The word install shall mean to build in, mount in positions, connect, or apply any object specified ready for the intended use. Provide. The word provide shall be understood to mean furnish and install. And finally, required or necessary. The words required or necessary shall mean as required or necessary for the complete execution of that portion of the work. Article 2. Execution, correlation, meaning of terms, and intent of documents. So first, what is the intent of the contract and what shall be the standard of conduct required of the parties? The intent of the contract is to include all labor, materials, equipment, and transportation necessary for the proper execution of the work, and each party to the contract acknowledges that, in the exercise of his rights and in the performance of his duties, he must act with justice, give the other parties due, and observe honesty and good faith. Next, what are the rules regarding the interpretation of contract under CIAP Document 102 in the case of conflict, discrepancies, errors, or omissions? So for Rule 1, the agreement and the contract documents shall be taken as mutually explanatory of one another. The various provisions of the contract shall be interpreted together, attributing to the doubtful ones that sense which may result from all of them taken jointly. For Rule number 2, the provisions of the Civil Code of the Philippines on the interpretation of contracts and of the rules of court on the interpretation of documents shall be applied. Next, we have Rule number 3. Where the conflict between or among the provisions of the agreement and/or the contract documents cannot be resolved by Rules 1 and 2, it shall be understood that detailed drawings shall prevail over the general drawings, words and figures shall prevail over the drawings, words shall prevail over figures in contract documents, and written dimensions shall prevail over measured dimensions. Now, for Rule number 4, where the conflict cannot be resolved by applying Rule 3 or where Rule 3 does not apply, the conflict shall be resolved by giving precedence to the agreement or to the provisions of a contract document higher in order of priority among the various documents which comprise the contract. The order of priority among these documents shall be as follows. A. Agreement as modified by notice of award of contract, if such be the case, and the contractor's conformity thereto, instruction to bidders, and any amendment thereto, addenda to bid documents, specifications, and drawings. We also have special conditions of contract, general conditions of contract, other contract documents, and other documents forming part of the contract attached thereto or incorporated therein by reference. Where the order of precedence is modified in the agreement, such modified order of precedence shall be followed. However, the mere listing of contract documents in the agreement or any other contract document shall not be interpreted as establishing an order of precedence among them. Rule 5. Where there is a discrepancy, defective description, error or omission in any contract document, the contract documents shall be interpreted as being complementary to each other. Thus, what is called for in one contract document, although not mentioned in another contract document where it should have been mentioned, shall be deemed. And finally, for Rule 6, the apparent silence of the drawings, specifications, or any other contract document as to any detail or the lack of detailed description concerning any part of the work shall be understood to mean that good and accepted construction practice in accordance with the usage or custom of the place shall be followed, to be called for by the contract. Next question. Who is responsible for resolving conflicts or discrepancies in the interpretation of the contract, and what is the consequence of the owner failing to issue the instruction in writing? Solely the owner is responsible for resolving such conflicts or discrepancies that may occur within the terms of the contract, and the interpretation of or explanation by the owner shall be issued in the form of instructions to the contractor. For the second question, the execution of the work affected by the interpretation or explanation without the owner's timely objection or protest shall be considered executed in accordance with the owner's interpretation or explanation. Thus, the owner cannot later on say that the work was done incorrectly. And for our last question, what is the responsibility of the owner with respect to performing acts which may affect the contractor's timely completion of the work? Article 206 enumerates some instances where the owner may be required to act, and such action may affect the contractor's timely completion of this work, such as giving his decision, opinion, or consent, expressing his satisfaction and approval, determining value, providing drawings, and supplying equipment or materials. Article 3. Drawings and Specifications. How many sets of drawings and specifications must the owner initially provide to the contractor, and how should the drawings and specifications be interpreted or understood? The owner shall furnish the contractor, free of charge, 3 sets of drawings and specifications, inclusive of the signed contract. All other copies of drawings and specifications as required by the contractor will be furnished to him at cost of reproduction. All drawings and models are to be read and understood together with the specifications to form a part thereof. Where figures are given, they are to be followed in preference to measurements by scale. Anything shown on the drawings but not mentioned in specifications or vice versa, or anything not expressly set forth in either but which is reasonably implied, shall be furnished as if specifically shown and mentioned in both. So for the last question, what are the clarifications that a contractor may request the owner regarding the meaning of drawings and specifications? These clarifications include the meaning of the drawings, including notes thereon, or of the specifications, any obscurity as to the wording of the specifications, and directions and explanations necessary and proper to make more definite and certain any requirement of the drawings, including notes or of the provisions of the specifications. Next, we have Article 4, Detailed Drawings and Specifications. How many additional detailed drawings and instructions should the owner provide to the contractor, and how should the additional detailed drawings and instructions be considered? For CIAP Document 102, it does not provide for an exact number. However, it provides that the owner shall furnish additional detailed drawings and instructions essential to their proper interpretation and proper execution of the work, and all additional drawings and instructions are to be considered of equal force as those which originally accompanied the specifications. Article 5. Shop Drawings. So first, what are shop drawings? Shop drawings represent all working and erection dimensions, arrangement and sectional views, necessary details including complete information for making connections with other work, and kinds of materials and finishes. Shop drawings shall also be dated, numbered consecutively, and shall contain the name of project, the descriptive names of equipment, materials and classified item numbers, and the location at which materials or equipment are to be installed in the work. Who prepares the shop drawings, and how many shop drawings should the contractor prepare and submit for the owner's approval? The contractor shall prepare all necessary shop drawings at his own expense. The contractor shall submit 2 copies of all shop or setting drawings, templates, patterns, and models. Submission of shop drawings shall be accompanied by a letter of transmittal in duplicate, or 2 copies, containing the name of the project, the contractor's name, number drawings, titles, and other pertinent data. If the shop drawings show variations from the contract requirements because of the standard shop practice or other reasons, the contractor shall make specific mention of such variations in his letter of submittal. So for our final question, is the owner responsible in all cases for the accuracy of drawings? Generally, the owner is responsible except if the contractor is a specialty contractor or is engaged by the owner as a specialty contractor, in which case it is the specialty contractor which is responsible in such case. The owner's approval shall not relieve the contractor responsibility for accuracy of such shop drawings, nor for proper fitting and construction of work, nor for furnishing of materials or work required by the contract and not indicated on the shop drawings. The owner's approval of such drawings or schedule shall not relieve the specialty contractor from responsibility for deviations from the drawings or specifications, unless he has, in writing, called the owner's attention to such deviations at the time of submission and secured the owner's written approval. And this ends my report for Section 1, Definitions and Documents. Thank you for listening.
Section 2, Laws, Regulations, Site Conditions, Permits, and Taxes.
Article 6, Laws and Site Conditions. 6.01, Laws and Regulations. In general, the contractor shall comply with all laws insofar as they are binding upon or affect the parties thereto or the work. He shall also comply with regulations of firms furnishing utilities such as water, gas, telephone, and electricity for the project. If the contractor performs any work contrary to such laws or utilities regulations, he shall bear all additional costs arising therefrom. 6.02 Site Conditions. Before the bidding and the awarding of the contract, the contractor is expected to have visited the project site and made his own estimate of the facilities required in and difficulties attending the execution of the work, on account of local conditions and all other contingencies. The owners shall, however, furnish the contractor a geodetic survey and subsurface exploration which the contractor may rely upon in the preparation of his bid. Article 7. Permits, Taxes, and Surveys. 7.01 Permits and Licenses. The owner with the contractor's assistance shall secure and pay all construction permits and licenses necessary for the execution of the work or of any temporary work and easements in relation thereto. The contractor shall secure the final occupancy permit, but he shall not be responsible to the owner if, without his fault, the license is not issued or there was delay in its issuance. Taxes. Wherever the law of the place where the project is located requires sales, consumer, use, or other similar tax related or pertinent only to the construction of the project, the contractor shall pay such tax. 0.03 Construction Stakes and Reference Mark. The owner shall furnish all surveys describing the physical characteristics, legal limitations, and utility locations of the site. He shall also furnish rights of way for access to the site. The owner shall be responsible for the establishment of lot lines, boundary lines, easements, and benchmarks, which shall be made by a certified surveyor. The owner may request the contractor to verify before the start of the construction the result of such surveys, provided the owner shall pay for the cost of such verification. The owner shall also pay for any damage or cost to the contractor brought about by errors in data furnished. 7.04 Services of Geodetic Engineer. The contractor shall, at his option, or when so required under the contract, engage the services of a licensed geodetic engineer to confirm and certify the location of column centers, piers, walls, pits, trenches, pipework, utility lines, and work of a similar nature. The geodetic engineer shall also verify and certify the lines and levels of any part of the work at any time, if so required by the owner. The certification shall be provided the owner and the contractor. If the geodetic engineer finds any deviation from the drawings in the work of the contractor, he shall report his findings to the owner within 24 hours from discovery.
Section 3, Equipment and Materials.
Section 3, Equipment and Materials. Article 8, General. All materials and equipment must conform to all laws now or which may be in force and applicable during the period of construction. The contractor shall bear all damages by reason of any delay in the work arising from his failure to comply with this provision. Where any revision or amendment to such laws is made during the construction period which affects the cost or time of completion of the contract, a constructive change in the work shall be recognized and the corresponding contract price and completion time adjustment shall be made. Article 9, Equipment. 9.01 Quality of Equipment. In order to establish standards of quality, the owner, in the detailed specifications, may have referred to certain equipment by name and catalog number. This procedure is not to be construed as eliminating from competition other products of equal or better quality by other manufacturers where they are fully suitable in design. 9.02 Equipment Substitution. The contractor shall furnish the complete list of proposed substitutions, preferably prior to the signing of the contract, together with such engineering and catalog data as the owner may require. All requests for substitution of equipment shall be in writing. The owner will approve or disapprove the request in writing. No substitute equipment shall be used unless approved in writing by the owner. The contractor shall abide by the owner's judgment as to which proposed substitute items of equipment are judged to be acceptable. Article 10. Materials, fixtures, appliances, and fittings furnished by the contractor. 10.01 Samples of materials. The contractor shall furnish for approval samples as specified or required. The work shall be in accordance with approved samples. From A to E. 10.02 Trade name materials and substitutes listed from A to D. 10.03 Testing samples of materials. The contractor shall submit to the owner as many samples as may be needed for purposes of testing. Testing of all samples shall comply with the specifications and government standards and shall be performed by a competent entity or testing laboratory approved by the owner. All costs of shipment, delivery, handling, and testing of contractor-supplied samples are to be paid by the contractor. 10.04 Quality of materials. Unless otherwise specified, all materials shall be new and their quality shall be of the best grade of their respective kinds, taking into account the nature of the project and requirements of the contract. 10.05 Storage and stockpiling of materials, as listed from items A to C. 10.06 Defective materials. All materials not conforming to the specifications shall be considered defective. The contractor shall remove or replace defective materials when ordered to do so by the owner. Upon the contractor's failure to do so, the owner may remove and replace them and deduct the cost of removal and replacement from any money due or to become due to the contractor. No materials, defects of which have been subsequently corrected shall be used until the owner's approval is given. Should the specifications, drawings, special provisions, and supplementary specifications fail to provide any detail or description concerning the nature and quality of the work to be performed, it should be understood that generally accepted construction practice shall be followed. 10.07 Imported materials, fixtures, and equipment. The contractor, taking into consideration the completion time, shall make timely arrangements for the purchase and delivery of all specified imported materials, fixtures, appliances, and equipment in order to avoid delay in the completion of the work. 10.08 Owner's approval. Unless specified to the contrary or unless the contractor's submission is deficient, equipment, samples, or materials submissions shall be acted upon by the owner within 7 working days of submission by the contractor. Article 11. Materials, equipment, fixtures, appliances, and fittings furnished by the owner. Materials, equipment, fixtures, appliances, and fittings specifically indicated in the contract shall be provided in accordance with the owner-approved construction schedule. Materials furnished by the owner shall be deemed acceptable for the purpose intended. Article 12. Royalties and patents. The contractor shall pay all royalties and license fees on all patented materials and processes furnished by him. He shall defend all suits or claims corresponding thereto for infringement of any patent rights and shall save the owner harmless from loss on account thereof. Article 13. Manufacturer's Directions. All manufactured articles, materials, equipment, appliances, fixtures, and fittings supplied by the contractor shall be applied, installed, connected, erected, used, cleaned, and conditioned by him in accordance with manufacturer's printed directions. Where reference is made to the manufacturer's directions, the contractor shall submit the specified number of copies such directions to the owner. Article 14. Use of premises. 14.01. Limitation of use. The contractor shall confine his apparatus, the storage of materials, and the operations of his workmen to limits indicated by law or directions of the owner, and shall not unreasonably encumber the work premises with his materials. The contractor shall not load or permit any part of the structure to be loaded with a weight that will endanger its safety. The contractor shall enforce the owner's safety instructions regarding signs, advertisements, fires, and smoking. Article 15. Temporary structures and facilities. 15.01. Temporary office and contractor's building. The contractor shall, taking into account the location and size of the site, at all times provide and maintain an adequate, weathertight temporary office with necessary basic facilities such as water, light, and telephone. 15.02. Temporary housing for workers. The temporary buildings for housing men or the erection of tents or other forms of protection will be permitted only at such places as the owner shall designate, provided, however, that if no particular area is designated, the contractor may use his own discretion in determining such areas in consultation with the owner. 15.03. Safety and sanitation. The contractor shall, from the commencement of the work until its completion, a. Furnish and put up all temporary barricades and guard lights necessary for the protection, proper prosecution, and completion of the work. B. Maintain guard lights at the top of the false work tower, barricades, railing, etc. C. Provide and maintain ample sanitary toilet accommodation and other necessary conveniences, including water connections for the use of personnel and laborers on that work, properly secluded from public observation in such manner and at such points as shall be provided or approved by the owner, and their use shall be strictly enforced. D. Keep such places clean and free from flies. And E. Remove all connections and appliances connected therewith prior to the completion of the work. 15.04. Temporary signs. No signs or advertisements will be allowed to be displayed without the owner's approval. The contractor may erect one painted sign giving the names and addresses of the owner, the contractor, and the various subcontractors. The owner shall approve the size, color, lettering, and location of such temporary signs. 15.05. Temporary or trial usage. Temporary or trial usage by the owner of any mechanical device, machinery, apparatus, equipment, or any work or materials supplied by the contractor before final completion and written acceptance by the owner shall not be construed as evidence that the owner has accepted it. Such test run shall be made by the owner for such reasonable length of time as the owner shall deem necessary. The owner shall not be liable for injury to or breaking of any part of such work which may be caused by weakness or inaccuracy of structural parts or by defective materials or workmanship. The contractor may, at his own expense, make such trial usage with prior notice to and for the benefit of the owner.
Section 5. Protection of Work and Property. The first article is the Article 16, which is the protection of work and the owner's property. Under this is the safeguard measures which is all about the contractor's responsibility. The contractor shall take all the responsible measures to protect from damage, which is the works, the owner's property, and the equipment, materials, appliances, and fixtures supplied or paid for by the owner, and shall make good any damage, injury, or loss, except such as may be caused by agents or employees of the owner, or due to causes considered as act of God. The next one is provide reliable and competent watchmen to guard the site and premises. Provide all the doorways with locks under his control and locks such as doors at the close of each day's work. Provided, however, that if the owner deems the security service inadequate or incompetent, the contractor shall increase or change the security personnel. The next one is prohibit smoking at the site, and signs to this effect shall be posted conspicuously. The next one is prohibits fires built on the site except by express consent of the owner. And lastly, provide and maintain in good working order an adequate number of firefighting equipment, and such equipment shall not be used for any other purposes. The next one is the section 16.02, which is all about old materials. All old materials of value as determined through a joint inventory by the owner and the contractor found at the work site shall be carefully stored at the place designated by the owner, and the contractor shall be responsible for their safekeeping until final acceptance of the work. The next section is the trees and other plants. Existing trees, plants, shrubs, and etc., which are to remain at the site shall be boxed and otherwise protected from the damage. No trees within the site located outside building lines shall be cut or removed without the specific approval from the owner. Under this is, when specifically included in the contractor's scope or work, all the trees and other plants that need to be transplanted elsewhere shall be done by the contractors in accordance with instructions of the owner. The next one is damage to trees, plants, shrubs, streets, sidewalks, and etc., resulting from fault or negligence of the contractor in connection with the execution of the work shall be made good and or replaced or repaired by the contractors at his own expense. The next one is the drainage. If should be necessary in the section of the work to interrupt or obstruct the natural flow of rivers or streams, the drainage of the surface or the flow of artificial drains, the contractor shall do so in such a way that no damage shall result to either public or private interest for his neglect to provide other means of drainage for any existing natural or artificial drainage which he may be obstructed and or interrupted. The contractor shall be liable for all the damages which may result therefrom. The next article is Article 17, which is the protection of adjacent property and existing utilities. Under this is Section 17.01, which is the contractor's responsibility. The contractor shall be adequately protect adjacent property as provided by the law and the contract. Any neighboring property or building which may be jeopardized in any manner must be thoroughly substantially protected against damage during the construction at the contractor's expense. Section 17.02. The contractor shall be liable for and pay for all damages to adjacent and existing utilities occasioned in any manner by his act or neglect or by the other of his agent, employees, or workmen. The next one is the Section 7.03, which is the condition survey. Prior to the commencement of the works, the contractor shall, insofar as is legally and physically possible, survey and ascertain the condition of any existing adjacent properties or buildings and record the results and thereof through photographic record or by any other means. The last article is the Article 18, protection of life, work, and property during an emergency. Under this is the Section 18.01, which is the authorization to contractor. In an emergency endangering life, the work, or the adjoining property, the contractor, even without special instruction or authorization from the owner, shall act at this discretion to prevent or minimize such threatened loss or injury. Emergency work performed by the contractor shall be treated as one performed under a change order unless the emergency was caused or brought about by his or negligence. Dito, makikita natin kung ano ang iba't ibang responsibilidad at pananagutan ng isang kontraktor sa isang construction sites. at kung ano ba ang mga dapat na hakbang upang maiwasan ang ganitong problema na dulot ng iba't ibang faktor katulad na lamang ng mga non-living things at living things na makikita sa karatig lugar ng construction. Katulad na lamang nito ay ang mga puno at ang iba't ibang constructions o buildings na malapit sa construction sites.
I am Rey Perez and I will be going to discuss the Section 6 of the Construction Industry Authority of the Philippines, which is the Labor, Works, and Payment. 19. The labor. What qualification or characteristics must the contractor's workmen have? The contractor's workmen should be competent and duly qualified professionals. The contractor should not employ careless and incompetent workers that may obstruct the work. L20. Work. Methods and appliances. The contractor shall use methods and appliances for the performance of the work, as will ensure the completion of the work of the required quality within the completion. If, before the commencement of the project, there are things that the owner does not approve of the method that are going to be used, the owner may order the contractor to improve their method or change their method for more efficient work. Article 20, Passage 2. The laying of the work. All stakes and benchmarks placed by the contractor in laying out the work and approved by the owner shall be carefully guarded and preserved by the contractor, unless such stakes or marks or displays are rendered useless through the carelessness or neglect of the owner or of his agents or employees. They shall be replaced by the contractor at his expense. Article 20, Passage 2. The defective work. Work that fails to comply with the contract is defective. Defective work shall be condemned by the owner upon discovery, and when such work has been condemned, it shall be immediately removed by the contractor and replaced in accordance with the drawing and specification. 20. Passage 4. The inspection of work. The owner shall have access at all times to the work. The contractor shall furnish without additional charge or reasonable facilities, labor, and materials necessary for the convenient inspection and test that may be required by the inspector. The owner should provide inspectors authorized to witness the pouring of concrete in the absence of the owner inspector at any time during the progress of the work shall be an implicit approval of the quality of the cement used in the authority to pour it. If the specification, the owner instructor, the law, or any public authority requires any work to be specifically tested or approved, the contractor shall give timely notice to the owner and other parties required to make or be present in inspection in time of such inspection. If any work should be covered up without timely notice to the owner or before the owner can make a timely inspection thereof, it must, if required by the owner, be uncovered for examination at the contractor's expense. However, notwithstanding the failure of the owner to make a timely inspection of the work before it is covered, its re-examination may be ordered by the owner, and if so ordered, the work must be uncovered by the contractor at the owner's expense. But if such work is found null in accordance with the contract, the contractor shall shoulder the cost of uncovering and redoing the work. There are indications that the work done is not in accordance with the drawings and specification. The owner may at any time before final acceptance of the work make an examination of the portion already completed by removing or tearing up the same. The contractor shall on request furnish all necessary facilities, labor, and materials. If such work is found to be defective in any material respect due to the fault of the contractor or his subcontractor, the contractor shall defray all the costs of such examination and of satisfactory construction. And all inspection and tests shall be performed as not to delay the work unnecessarily. Article 20, Passage 5. Work during an emergency. The contractor shall perform any work and shall furnish and install all materials and equipment necessary during an emergency endangering life or property. In such cases, Article 18 Passage 1 shall apply. Article 20 Passage 6 increase or decrease quantities of work. Adjustment in works drawing to suit field condition which cannot be foreseen at the time of calling for bids may be necessary during construction. It is the essence of the contract to recognize such changes in drawing as normal. The resulting change in quantities or the increase in the scope of work of the contractor shall be covered by a change order. Work done by the contractor without timely notice to the owner that an adjustment is required of contract price and completion time shall be at his own risk and expense. Passage 7. Changes in the work. Change order by owner. The owner may at any time order extra work or make changes by altering, adding to, or deducting from his scope of work and within the general scope thereof, provided, however, that the resulting overruns or underruns from the quantities or costs in the bid do not exceed 25%. Such changes shall be ordered by the owner in writing. Changes of subsurface condition. If during the progress of the work subsurface conditions at the site materially different from those shown on the drawing or indicated in the specification or in the contract document are discovered or encountered, the attention of the owner shall be called at such condition before they are disturbed. The work shall be executed under the condition of the contract. If changes under paragraphs A and paragraph shall cause an increase or decrease in the amount due under the contract or in the time required for or money of its performance, an equitable adjustment shall be made and the contract modified accordingly. The values of extra work. The value of any extra work or change shall be determined by the owner in any one or more of the following ways: by a lump sum acceptable to the contractor, by a unit price either stipulated in the contract or subsequently agreed upon, provided the aggregate value of changes does not exceed 25% of the original contract price of the particular paid item, by actual direct cost plus value added tax, if any, plus 15% for contractor's profit and overhead. Of extra work to other contractors. In case any extra work shall be required in the project performance of the work, and the contractor and the owner shall fail to arrive at any agreements as to the adjustment of contract price and or completion time, the owner may award such extra work to another contractor. Passage 8. Claims for extra cost. If the contractor claims that any instruction by the owner or the drawings or a specification issued after submission of the bid involve a change, shall give the owner written notice thereof within 15 days after the receipt of such instruction, drawing, or specification as much as possible before proceeding to execute the work, except in an emergency. Passage 9. Claiming after the completion of work. All of the things that are not going to be used or recycled anymore should be cleared off inside. The contractor shall always keep the site clean. Passage 10. Use of completed portions of work. The owner may take possession of completed portion or partially complete, as long as they keep at ease. But taking possession of that portion does not mean it is already accepted. Passage 11. Substantial completion and its effect. There is substantial completion when the contractor completes 95% of the work, provided that the remaining work, the performance of the work necessary to complete the work, shall not prevent the normal use of completed portion. The owner shall be deemed to have recognized substantial completion of the work through the approval by the owner of the contractor's billing for completing at least 95% of the work. The issuance of certificate of substantial completion are equivalent document. However, the dates of this document should not be controlling if the substantial completion is shown to have been made at an earlier date, unless the contractor accepts the certificate without taking exceptions thereto in writing within 15 days from receipt. the equipment, fixtures, and furnished and/or installed by the contractor, which the contract requires to be test run prior to the acceptance, shall be the test run successfully before the work can be accepted as substantially completed. The owner shall without delay cause the test run of the facility. Should the constructor be unable to completely install or furnish and test run the facility through no fault of his, the contractor shall automatically be entitled to an extension of completion time equal to the period of delay. Issue to the contractor one or more lists of defects found or discovered on the completed work, otherwise known as a punch list or list, which the contractor must receive from the owner not later than 30 days from date of substantial completion. The owner may add to the punch list items but only as to corrected work on the items in the original punch list or list not later than 60 days from the date of substantial completion. Repeated damage or delay beyond the completion time shall accrue after the date of substantial completion of the work. If the targeted date of completion has arrived and the contractors cannot achieve 95% completion of the work due to the uncompleted facility caused by the owner's fault, the contractor shall be deemed to have achieved substantial completion provided the contractor has completed at least 95% of the work minus the uncompleted facility. The contractor has completed the work required in the facility, but for that which is directly affected by the owner's fault, the owner shall release to the contractor the contract price list because of the completed portion of the work and amounts mentioned in Article 22, Passage 3. Second is to ensure that the contractor is paid for work completed and for the owner to retain such portion of the contract price which, together with the performance bond, is sufficient to complete the work without additional cost to the owner. Period of making good of known defects or faults. The expression periods of making good of known defects or faults shall mean a period of not more than 30 calendar days calculated from the date of receipt by the contractor of the last item in the punch list submitted during the period provided in Article 20, Passage 11, during which the contractor shall complete the corrective works. Article 20, Passage 30. Making goods of known defects or faults. The contractor shall execute his own expense all the work necessary for making good of known defects, imperfections, or faults within the period stated in Article 20, Passage 12. Special test inspection. Special test inspection or approval not otherwise required in a contract which the owner instructs the contractor to perform after the date of substantial completion shall be treated as a separate work which shall be covered by the supplemental agreement. Passage 15. The acceptance of non-conforming. If the owner accepts defective or non-conforming work instead of requiring its removal and correction, the owner shall issue to the contractor a change order to reflect a reduction in the contract price where appropriate by an amount not exceeding the value of the unfinished work as determined the breakdown of work and the corresponding value. Passage 16. The adjustment of prices. There shall be added to or deducted to the contract price such sum affecting the execution of the work thus by the end of the following. Adjustment of prices due to the escalation or reduction of cost of executing the work shall be made use of parametric formula to be agreed upon 30 days by the parties. In default of such agreement, the parametric formula under applicable law shall be applied. Such an adjustment shall be made to provide equitable relief to both the owner and the contractor, allowing neither to gain nor lose by such application. The adjustment of prices shall be determined on the basis of the original contract unit price of labor and materials and such unit prices in effect during the relevant period of working accomplishment. Price shall be adjusted not oftener than once a month due to the increase or decrease of the direct cost of labor and materials of more than 5% the original contract unit price of the relevant items of work. The adjustment shall include the first 5%. In any case, the project is behind schedule by more than 15% from the approved construction schedule, not with the excusable delays. The payment for work accomplished shall be made on the basis of the contract price as adjusted in accordance with the escalation rate applicable during the period in which it should have been accomplished. This Article 20 policy shall not apply to an increase or decrease in the cost of the materials and service provided or supplied by the owner. Passage 17. Payment in legal tender. Payments in money under the contract shall be made in the currency stipulated, and if it is not legally possible to deliver such currency, then in the currency which is legal tender in the Philippines.
Section 6. Time of completion of work. When does the work commence and what is the period for its completion? Construction starts within 7 days upon receiving the notice to proceed unless may later date na in-state sa contract. For premature commencement, it is in the risk of the contractor unless mutual decision yun ng owner and the contractor, and the owner gave the contractor authority to start the work earlier. For completion naman, it shall be completed in accordance with the contract in a fixed date. What is the construction schedule and what is its content? Construction schedule contains the approximate date each paid item will be started and completed, the equipments to be used, and number of men needed to complete the work and schedule, and this must be submitted immediately after the contract is effective. What happens in case of slippage or delays? In case of delay, pwede magpatawag ng meeting ng owner, and kapag napag-alamanan na ang delay is caused by the contractor's negligence, the contractor must submit a catch-up schedule at dapat approve ito ng owner. Can the owner accelerate the schedule? Yes, pero dapat siya magbayad ng extra. Pero kung dahil ito sa contractor kesyo mabagal ang development, the contractor will handle the expenses of the acceleration. Can the contractor ask for an extension of time? Yes, pero may instances lang, and this includes the reasons stated above. Ang contractor ay not entitled sa extension of completion of work of time kung ito ay dahil sa alleged failure of the owner to furnish materials or information or provide drawings unless nakastate sa construction schedule na approved ng owner at siya ang may pagkukulang. Ang delay naman sa payment ng progress billing shall extend the completion time. What happens when there is a delay in the completion of work? Kung may delay, liable ang contractor, and pwede mag-deduct ang owner sa contractor base sa araw ng delay ng completion of work. Article 22 of Section 6, Payments. How are the payments determined and paid? In 15 days of receiving the notice to proceed, dapat nakapag-submit na ang contractor ng breakdown of work and corresponding value of the contract amount. Ito na ang basehan ng bayad sa completed and uncompleted works. Also, ito na rin ang magiging basehan for compensation. Each request for payment is computed, less 10% of the progress payment to the contractor. Kung kalahati na ng contract ang tapos na, wala ng retention ang dapat na gawin. Kung na-submit na ang request, dapat within 30 days, ma-evaluate, ma-certify, and mabayaran na iyon ng owner, or else magbabayad siya ng interest. Is the approval of the owner of a progress billing merely provisional, or is it considered final? The approval is merely provisional. The owner has the right to reevaluate or remeasure the work of its contractor. Can the owner deduct anything from the payment to the contractor? Yes, the owner may deduct for A. the estimated cost of defective work not remedied, B. the amount of substantiated and unpaid claims by subcontractors and suppliers unjustifiably withheld by the contractor, and C. the amount which has accrued as liquidated damages. Who has the duty to pay the laborers, subcontractors, and suppliers? The contractor has the duty to pay all workmen, materials, rentals, and taxes due for him. Other than the submission of a request for payment, are there any other documents or requirements that the contractor must complete? Yes, the contractor shall submit before final payment several documents including the ones listed. What happens during the final payment? Kung na-notify na ang owner na tapos na ang construction, within 10 days from receipt of the notice, proceed to verify the work, make final estimates, certify the completion, and accept the same. The acceptance by the contractor shall constitute a waiver of all his claims against the owner, except the following: a claim covered by a prior notice to the owner received by the contractor to be filed in accordance with the contract, a claim pending before and unresolved by the owner at the time the request for final payment is made, a dispute referred to arbitration in accordance with Article 34.05, and a claim which the owner acknowledges with the payment not to be covered by it. Except for that causes, the owner shall pay for the contractor within 30 days. Can the contractor be held liable for defects or inferior works after final payment? Yes, kung may hidden defects na di agad nakita ng owner, and the owner accepted the work with express reservation seasonably made, or if the owner finds the work poor, may 1-year defects liability period kasing tinatawag. Can the contractor be held liable for any loss or damage suffered by third person from any defects of the work? Yes, and it is stated in the Article 1723 of the Civil Code. When can the funds retained by the owner in accordance with the contract be released? Amounts retained shall be released not later than the expiration of the period during which the contractor shall complete corrective work on punch list items upon the posting of the contractor's guarantee board.
So good day, I'm Joegimel Ramos and I'll be presenting Section 7 and Section 8, which is the contractor separate, contractor-subcontractors relations, and suspension of work and termination of contract, respectively. So, i-discuss ko lang dito yung mga questions regarding the sections at masasagot naman to ng mga articles na napapalooban sa mga sections. Okay? Article 23, separate contracts with other contractors. Number 1, can the owner have separate contracts with other contractors? Yes, the owner may perform work outside of the contractor's scope of work or award separate contracts to other contractors. So, dahil pwede, pero kung nakakita ng contractor na it causes delay, damage, and additional costs, the contractor shall make such claim as provided in the contract. Article 24, contractor separate, contractors relation. Question number 1, what are the possible obligations that the contractor may have with separate contractors? So nagbigay dito ng tatlong obligations which are storage of materials and work, cutting, fitting, or patching of work, effective work by separate contractors. Yung una, yung storage of materials and work. Ang kagamitan ay maaaring itago ng contractor sa construction site mismo, ay kailangan rin ng consent ng may-ari at kailangan ipaalam sa separate contractor para ma-minimize ang interference and obstruction sa construction site. Sa cutting and fitting or patching of work naman, ang bawat contractor ay responsable sa kanya-kanyang gawain tulad ng cutting, fitting, or patching of work na nakabase naman lagi sa drawings and specifications ng plano. Number 3 is the defective work by separate contractors. Kung may defect or may ginawa ang separate contractor na hindi naman nakasaad sa kanyang kontrata, ay kailangang ipagbigay alam ito ng contractor sa owner. Number 2, what if the contractor causes damage to the work of separate contractor? Should contractor agrees to relieve the owner of any liability. On the other hand, should a separate contractor cause damage of on the constructor's work, then the owner shall hold harmless the contractor in respect thereof. Article 25. Subcontracts. Number 1. Can the contractor contact another entity to complete a portion of the work? Depende siya sa owner kung payag o hindi. Kung payag, ay ibig sabihin lahat ng gagawin ng subcontractor ay responsibilidad na ito ng contractor na kumuha sa kanya. Section 8. Suspension of work and termination of contract. Article 26. Contractors right to suspend work or terminate contract. Question number 1. Can the contractor suspend work or terminate the contract? Ay nagbigay dito ng 6 na rason na maaring ang contractor mismo ang mag-suspend at mag-terminate ng kontrata. Number 1 is order of a court or other public authority. Court order to suspend the work a period of 90 days lang. Number 2, if the owner shall fail to pay the approved request for payments. Ibig sabihin ay kung hindi makapagbabayad or hindi makabayad ang owner sa contractor ng napagkasundo ang presyo. Number 3, if the owner suspends the work without just cause for more than 15 days without contractor consent. And number 4, if the owner delays the approval of variation orders for more than 15 days after submission. So yung variation of orders ay refers to any change of scope of work, planning, specification, or contract document. Pag nagbigay ang contractor sa owner ng mga change of scope of work or planning at specification sa construction or sa plano, pag hindi ito napirmahan agad or na hindi na-aprobahan agad ng owner ay maaari ang contractor mismo mag-suspend or mag-terminate ng contract. And last, if the owner fails to deliver at a construction site, the owner supplied material or equipment beyond 15 days. So, ibig sabihin ay kung ang owner mismo hindi makapagbigay or makasupply ng mga materials at equipment ayon sa kontrata, kasi may mga kontrata na yung owner mismo ang mag-provides ng gamit para sa construction. Number 2, where the suspension or termination of contract affects the completion time or the contract price. Yes, lagi naman talaga. At may karapatan na ang contractor na makialam sa pagbabago ng schedule at lalong-lalo na about sa contract price. Article 27, owner's right to suspend the work. Question number 1, can the owner suspend the work without cause? If so, how long? Yes, kahit walang rason, maaring i-suspend ng may-ari ang work sa loob ng at hindi lalagpas sa 15 days. Dahil doon, may karapatan ang contractor na i-adjust ang contract price. Number 2, can the owner suspend the work for more than 15 days? Generally, hindi siya pwede ilagpas sa 15 days ang suspension. Pero, if there is a just cause or the contractor consent to a longer suspension, so ibig sabihin, pwede nang lumagpas sa 15 days yung suspension. At ano-ano ang dahilan para i-suspend ng lagpas 15 days ang construction? Number 1 is unsuitable weather condition, tulad ng bagyo at iba-iba pang mga weather condition na makakasagabal talaga sa trabaho. Number 2, failure of the contractor to correct conditions or to correct defective work. Number 3, failure of the contractor to carry out valid orders issued by the owner, and necessity for adjusting the drawing to suit the site condition, and failure of the contractor to supply skilled workers, materials, or equipment. So dito, sabi ko sa nauna, is may mga ilang kontrata na yung owner mismo ang magsusupply ng equipment. Dito naman is yung contractor yung maghahanap ng mga skilled workers, materials, at equipment. And 6, failure of the owner to supply owner-supplied or furnished materials on time. 7, delay by the owner to obtain right-of-way. 8, force majeure or fortuitous. Ito yung mga out-of-hand na event tulad ng gera, kung sakali man, huwag naman saan. And 9, peace and order problem. And 10, any condition similar to the above beyond the control of the owner. Article 28, owner's right to terminate contract. Number 1, can the owner terminate contract without prior notice to the contractor? Yes, upon occurrence of any following events. Number 1, if contractor is adjudged bankrupt or insolvent. 2, if contractor make a general assignment of his assets for the benefit of his creditors. Number 3, if a trustee or receiver is appointed to the contractor or for any of the contractor's property. And last, if the contractor files a petition for suspension of payments or for reorganize under the bankruptcy law. Number 2, are there instances when the owner is required to give prior notice before terminating the contract? Answer is yes. The following grounds for termination with cause require 15 days written notice. Number 1, the contractor repeatedly fails to supply sufficient number of skilled or workmen, or suitable materials or equipment in the schedule. Number 2, a contractor repeatedly fails to make without just cause prompt payments to subcontractor for labors, materials, or equipment, and completion of the work is being delayed. Number 3, the contractor disregarded the laws or orders of any public body having jurisdiction. And last, the contractor otherwise violates in any substantial way any provision of the contract. Number 3, what happens if the owner terminates the contractor with cause? The owner may exclude the contractor from the site and take possession of the work and of all the contractor's tools, appliances, construction equipment, and machinery at the site which the owner has paid the constructor. Number 4, can the owner terminate the contract without cause? Yes, upon 15 days written notice to the contractor. And the owner may, and without prejudice to any other right or remedy, elect to abandon the work or terminate the contract for its convenience. In such case, the contractor shall be paid for all works executed and any expenses sustained plus reasonable termination cost. Article 29, owner's right to proceed with the work after jurisdiction in contractor's scope of work, partial takeover from contractor. Number 1, when can owner elect to carry out the work? The owner may, after 7 days following the receipt by the contractor or written notice and without prejudice of any other remedy, the following may have and without terminating the contract, elect to carry out the work if the contractor, number 1, repeatedly fails to supply sufficient skilled workmen or suitable materials and equipment. Number 2, repeatedly fails to make prompt payments to subcontractors for labors, materials, or equipment. Last, fails to perform the work in accordance with the contract. Number 2, what happens to the materials and equipment at the site? Kailangan alisin ng contractor ang mga materials and equipment na hindi naman kailangan ng owner para sa project. At kung ang materials or equipment ay hindi pa gamit-ari ng contractor, may choice ang owner kung gagamitin niya ito o hindi. At kung gagamitin naman ay kailangan magbayad ng renta or upa para sa mga materials and equipment na gagamitin ng owner. Number 3, what are liquidated damages? Liquidated damages are those agreed upon the parties to a contract to be paid in case of delay in completion of the work. At yun lang. Thank you.
So hello guys, I'm Rey Perez and I will tackle sections 9 and 10 of the Construction Industry Authority of the Philippines CIAP Document 102, Uniform General Conditions of Contract for Private Constructions. So, in Section 9, it includes the responsibilities and liabilities of contractor and of owner. So let's have an overview. It includes Article 30, or the contractor's responsibility for accidents and damages, Article 31, contractor's insurance and bonds, Article 32, owner's responsibilities and liabilities, and lastly, Article 33, clients, disputes, and arbitrations. Article 30 of Section 9, contractor's responsibility for accidents and damages. Article 30.01, safeguards to be undertaken by the contractor. The contractor shall always take all necessary precautions for the safety of employees and workmen on the work and comply with all laws. This will prevent injury to persons on the premises where the work is being performed. The contractor also shall erect and properly maintain at all times. This will be done by putting barriers, shoring supports, braces, lights, danger signs, and necessary safeguards as will protect workmen and the public. The contractor shall designate a responsible member of his organization at the site, whose duty shall be the prevention of accidents and damage to the work, the owner's property and adjoining property. The contractor shall be primarily responsible for all safety measures in prosecuting the work in accordance with the safety manual approved by the Construction Industry Authority of the Philippines, or CIAP. The next one is Article 30.02, or owner not to be responsible. The contractor shall render the owner free and harmless for the death of, the disease contracted or injury received by the contractor or any of his employees or laborers, for any damage done by or to the constructor's plant or materials from any source or cause, and for damages caused by the contractor or his employees to any property of the owner and adjoining property. Nangangahulugan lamang ito na kung ano man ang mangyari na nasa sakop ng trabaho ng contractor at ng mga trabahador niya ay walang kinalaman dito ang may-ari. Ang lahat ng mangyayari sa work area ay dapat lamang nasagot ng contractor. The contractor shall indemnify and save harmless the owner from and against all losses and all claims, demands, payments, suits, actions, recoveries, and judgment of every nature and description brought or governed against him, for any act or omission of said contractor or of his agents or employees in the execution of the work or the guarding of it. This means that if ever there is a problem at work, it's the constructor's duty to protect the owner, because he is not responsible for any misfortunes regarding the death, injury, or damages caused by the contractor and his employees. Claims for payment and repairs for damages for which the contractor is liable shall be settled by the contractor at his own expense. So, kung may mangyari man sa site, walang kinalaman doon ng owner. Nasa pangangalaga yun ng contractor. The next one is contractor's default. So, ang contractor's default, it means that the constructor's inability to perform their contractual obligations within the timescales detailed in the contract. The owner shall have the right to undertake reasonable safety and protection measures in case of constructor's default and charge the cost of such measures to the contractor. So kapag nawala man sa site yung contractor, pwedeng mag-take over yung owner at i-charge yung pag-take over niya dun sa contractor. Next one is Article 31, Contractors, Insurance, and Bonds. Insurance is a contract represented by a policy in which an individual or entity receives financial protection or reimbursement against losses from an insurance company. On the other hand, bonds is what protects the client against disruptions or financial loss due to a constructor's failure to complete a project or failure to meet project specifications. By submitting a construction bond, the party managing the construction work states that they can complete the job according to the contractual policy. So what are the kinds of insurance required of the contractor? Here are some. First one is in Article 31.01, Contractor's Liability Insurance. The contractor shall secure and maintain insurance coverage from an insurance company acceptable to the owner as will protect himself, his subcontractors, and the owner from claims for bodily injury, death, or property damage which may arise from work under the contract. So, kailangan muna may insurance na parehong sinasang-ayon ng contractor at ng owner. Bago magsimula ang trabaho, dapat ayos ang mga insurance policy at applicable ito sa lahat. The contractor shall not commence work under the contract until he has obtained the insurance coverage required and shall have filed the insurance policy or the certified copy of insurance policy with the owner. The next one is 31.02, Accidents Insurance for Workers. The contractor shall obtain insurance coverage for accidental death or injury of his officers, employees, and laborers, without regard to their tenure of employment as permanent or regular workers, project workers, or casual employees performing work at the project site in an amount of not less than 100,000 per officer, employee, or laborer. So, aside from the compulsory coverage of workers under the Workmen's Compensation Law, meron din itong insurance na para lamang sa kung may naaksidenteng manggagawa habang nagtatrabaho. At hindi bababa sa 100,000 pesos ang ibibigay na kabayaran. The next one is Article 31.02, Contractor's Fire Insurance. In addition to such fire insurance as the contractor elects to care for his work, he shall secure and maintain the policies upon such structures and materials, and in such amounts as shall be designated in the joint names of the contractor and the owner, as their respective interests may appear. So, next one is the bonds. What are the bonds required of the contractor? So, one of the bonds is Contractor's Performance and Payment Bonds. The contractor, prior to signing the contract, shall furnish a performance bond equal to 15% of the contract amount for the faithful performance of his work, and 15% bond covering contractor's obligations arising from the contract to its workers, subcontractors, and suppliers. So, ang performance bond na sinasabi dito is yung shares from the total contract amount para sa performance ng contractor. Meron din ito para ensure ang client against sa risk na baka di magampanan ng contractor yung duties niya. Pwede itong may issue through insurance or kaya ng bangko. Such bonds shall be in the form of surety bond as approved by the owner and shall remain in effect until replaced by the constructor's guarantee bond. Sunod naman ay ang contractor's guarantee bond. The performance and payment bonds will be released by the owner upon posting by the contractor of a guarantee bond, equivalent to the amount of the retention released to the contractor. The guarantee bond shall be for a period of 1 year, commencing from the date of posting as a guarantee that all materials and workmanship installed under the contract are of acceptable quality. So, guarantee bond, these are funds released to the contractor once work is done and it guarantees the great work or at least of acceptable quality. The next kind of bond is the contractor's guarantee warranty. The contractor shall, in case of work performed by his subcontractors and where guarantees are required, secure guarantees from said subcontractors and deliver copies of the same to the owner upon completion of work. The term guarantee shall include warranty. So kapag kumuha ng subcontractor yung contractor, dapat meron din silang guarantee bond. Ito ay tinatawag na guarantee warranty. So letters B, C, and D are other guarantees by the contractor. Letter B, the contractor shall and thereby guarantees all work performed by him directly and for which guarantees are required. Letter C, the contractor shall guarantee for a period of 1 year or for a longer period, where so provided in the specifications, all materials and workmanship installed under the contract to be of acceptable quality in every respect and to remain so during the guarantee period. Just like is stated from the previous slides, yun yung conditions. And letter D, should any defect develop in aforesaid work within the guarantee period due to fault in material and or workmanship, the contractor shall make all repairs and do all necessary work to correct defective work to the owner's satisfaction. Another for Article 31.06, letter E, in case the contractor fails to commence or do the work so ordered, the owner may have the work done by another contractor and charge the cost thereof against monies retained as provided for in the contract and or against his sureties. So kung may nag-fail sa trabahong nagawa ng contractor within the 1 year period before ibigay yung guarantee, tapos di niya yun inayos agad, pwede ipagawa yun ng may-ari sa ibang contractor. And ang ibabayad sa nag-ayos ay babawas dun sa retention funds na dapat ibibigay sa contractor. The foregoing remedies shall be without prejudice to the rights of the owner under the new civil code and other laws, now or hereafter, that may be applicable. Article 31.07, Mandatory Conditions of Bonds. So, ano muna yung bonds? Ang bonds nga ay parte ng kontrata na pinupos ng contractor upang ipakita sa kliyente na dahil sa bonds ay maayos sa trabaho ang ibibigay nila. The bonds required of the contractor shall be subjected to the following mandatory conditions, which shall form part of said bonds. A surety or bondsman issuing any bond called for in the contract is deemed conclusively to have accepted the following mandatory conditions. So, here is the first condition. Letter A, the surety or bondsman agrees in advance to future innovations of the bond either by adjusting the scope of the work of the contractor caused by directed or constructive changes, the completion time, or the contract price. Letter B, the bond issued shall continue to have force and effect beyond the effectivity period stated in the bond, if the work or the obligation for which it was issued has not been completely performed. So, pag di natapos yung trabaho na sa kontrato within sa tinalagang period, yung bonds na inisyo para din ay effective pa din kahit lampas na sa pagkasundaang panahon. This is without prejudice to the right of the surety or bondsman to demand from the contractor the payment of the premium on the bond or to the right of the owner to pay such unpaid premium for the contractor. The additional premium on the bond for an extension of the contract time due to reasons other than the fault or negligence of the contractor shall be billed at cost to the owner. The bond may not be cancelled or otherwise terminated by the bondsman or surety without the express written consent of both the owner and the contractor. The right of the surety shall be limited to demand the payment of unpaid premium. So dito naman, may karapatan yung bondsman na mag-demand ng karagdagang bayad o premium pero hindi niya maaaring i-terminate yung contract. The bond protects against disruptions or financial loss due to a constructor's failure to complete a project or failure to meet project specifications. Letter C of Article 31.07. The owner shall have a right of recourse against the surety on the bond until A. It is cancelled by the owner and returned to the contractor, or B. It is replaced by another bond unless the owner reserves the right to recover against the former bond due to default of the contractor, or letter C, the owner issues to the contractor an unconditional certificate of acceptance of the work. And dito naman sa fourth condition, letter D, until the owner takes over the work that only a part thereof, or otherwise terminates the contract, the contractor shall not be deemed in default, notwithstanding the reduction of the contractor's scope of work and any assistance provided by the owner to enable the contractor to catch up and complete the remaining work. The owner's assistance to the contractor shall not prejudice nor limit the right of the owner to have a later recourse against the bond. So sa fourth condition, karapatan ng owner na palitan na napagkasundo ang bond sa kontrata in case of the constructor's negligence of work. At sa case ito, ang owner na ang nagpapamahala sa trabaho. Article 32 of Section 9. Owners' responsibilities and liabilities. Part of the responsibility and liability of the owner is Article 32.01, which is advance payment. An advance payment in an amount to be mutually agreed upon shall be paid by the owner to the contractor, provided that the contractor shall post a surety bond of equivalent amount callable on demand and acceptable to the owner to guarantee its repayment. So, a bond is callable on demand when the surety is obliged to pay the owner upon its call. So, once tumawag yung owner, dapat may nakaredy ng pambayad. It means payable on demand. The contractor shall use the advance payment for mobilization, purchase of materials, and the like for the project. Article 32.02 of Section 9. Protection of employees and professionals performing services for the owner. The owner shall be responsible for and shall maintain such insurance as will protect him from liability for personal injury including disease and death of persons under his employ or services, whether as temporary or permanent in status that are assigned to the project. Article 32.02 Owner's Optional Insurance. So this is optional now, the word itself. The owner may maintain such insurance as will protect him from his contingent liability for damages for personal injury, including death, which may arise from the work under the contract. Next is additional information and services required of the owner. The owner shall, at the request of the contractor at the time of the execution of the contract, furnish to the contractor reasonable evidence that the owner can fulfill its obligations under the contract. Unless such reasonable evidence is furnished, the contractor may not be required to execute the contract or to commence or continue the work. So kung wala nito ang owner, pwedeng hindi mo na simulan ng contractor ang trabaho. Last part of Section 9, Article 33, Liens, Disputes, and Arbitration. Lien is the right to keep possession of property belonging to another person until a debt owed by that person is discharged. Dispute is synonymous to a disagreement, argument, or debate. And arbitration is a procedure in which a dispute is submitted by agreement of the parties to one or more arbitrators who make a binding decision on the dispute. In choosing arbitration, the parties opt for a private dispute resolution procedure instead of going to court. Article 33.01 Liens. As a condition to final payment and or the release of the retention, the contractor shall release the work from any legal liens attaching therewith as a result of unpaid claims of subcontractors and or suppliers for the supply of materials and or equipment to the contractor for the project. The contractor cannot release the work if there are legal liens attached to it. And the documents that should be executed by the contractor in respect to the said attached liens is a sworn statement by the contractor or a duly authorized officer of the contractor stating that all such claims have been fully paid and furnishing the owner, when required, with receipts or acknowledgements of payments issued by the subcontractors and or suppliers. Should any of such claims remain unpaid as of the time of executing the sworn statement, or if the contractor is unable to furnish the owner with proof of full payment to any subcontractor or supplier, the contractor shall furnish the owner with an indemnity bond equal to the amount of the claims still unpaid. The indemnity bond may be issued by the surety which previously issued the contractor's performance bond, or any bond required under the contract, or by any other surety acceptable to the owner. The owner may recover against the contractor and or the surety, on the latter's indemnity bond, any amount paid by the owner to discharge such liens, including costs incurred incident thereto, and a reasonable amount of attorney's fees. Article 33.02 Assignment. The contract may not be assigned in whole or in part. Any purported assignment made of the contract or any part thereof without the consent of either party shall be void and ineffective. So contract cannot be assigned. It is a collaborative work. Letter B. The owner may nevertheless exact full compliance from both the contractor and his assignee, without waiving the owner's right at any time thereafter to reduce the contractor's scope of work by removing from the contractor the part of the work which was assigned and giving it to any other contractor, and or terminating the contract in either case, without any further cost than the assignment. Letter C. Any contract, agreement, or binding written commitment entered into the contractor either before or after the execution of the contract with any other person as cooperator, consortium, member, joint venture member, or supplier of equipment, technology, materials, or services for the joint execution of the work shall be provided to the owner at the latter's request. If the owner finds that the contract, agreement, or binding written commitment is disguised assignment of the contract, the owner shall so notify the contractor and shall have the rights under paragraph B above, or from the other side. Article 33.02 Subcontracting. Letter A. The contractor may subcontract any part of the contract with the approval of the owner. And letter B. The owner may require the contractor, as a condition for the approval of the subcontract, that the subcontract shall be submitted to the owner, and the subcontract must require the subcontractor to obtain the same bonds and insurance coverage as are required of the contractor under the contract, and that the contractor furnish the owner copies of these insurance policies and bonds. Article 33.04 Disputes. Dispute is synonymous to a disagreement, argument, or debate. All matters which under the contract shall be accepted, approved, or decided by the owner may be entrusted by the owner to his authorized representative for determination within a period of 15 days. The latter shall in all such matters act as agent of the owner, whose determination binds the owner. If the contractor disagrees with the determination by the owner or by his representative, such disagreement shall be brought before an adjudicator, who shall be jointly engaged by the owner and the contractor, not later than 15 days, before the commencement of the work, to resolve conflicts arising from the foregoing determination by the owner or by his representative. If either of the party disagrees with the resolution of the adjudicator, such shall be deemed as a dispute which may be submitted to arbitration. Article 33.05 Settlement of Disputes. Dispute or disagreement submitted to arbitration. Any dispute arising out of or in connection with the contract, including any question regarding its existence, validity, or termination, not resolved as provided above, shall be referred to and finally resolved by arbitration under the rules of procedure governing construction at arbitration promulgated pursuant to Executive Order No. 1008 or the Construction Industry Arbitration Law, by a panel of 3 arbitrators appointed in accordance with such rules. The place of arbitration shall be in Metro Manila, Philippines. Resort to arbitration shall be made by filing claim with the Construction Industry Arbitration Commission. So the law that governs dispute is the Executive Order No. 1008 or Construction Industry Arbitration Law, and it is held in Metro Manila, Philippines. Letter B of Article 33.05 Substituted Service. A party to the contract shall, by entering into the same, be deemed to be submitting himself to the jurisdiction of the Construction Industry Arbitration Commission with regard to any dispute arising out or in connection with the contract. Such party shall be served with the claim referred to in Article 34.05, Paragraph A, and other notices and processes incident thereto upon such claim being served upon, or filed with his co-venturer, partner, or authorized representative, notwithstanding any statement to the contrary in the agreement, contract documents, or any other communication with the other party or after entering into the contract, unless he has filed with the Construction Industry Arbitration Commission an irrevocable special power of attorney authorizing another person or entity to receive the personal service at a definite address in Metro Manila, Philippines. Such claim, notice, and processes. In case a party, his co-venturer or authorized representative declines service of such claim, notice, or process, or cannot be found at his given address, such service shall be made upon the said party by filing the same with the Construction Industry Authority of the Philippines or CIAP at its office address. In filing the claim, notice or process shall complete the service upon the party concerned. So now, we are here in section 10, Owner's Representative. Article 34, Owner's Representative. The owner's representative shall either be the architect, the engineer, construction manager, or other person designated by the owner as the owner's representative. So, either of the three can be the owner's representative pag wala pang na-assign. The owner's representative shall have the full authority to act for and on behalf of the owner in all matters, which under the contract the owner shall give his consent, approval, or decision. The owner shall give the contractor at the time of the notice to proceed or any time thereafter the notice of appointment of the owner's representative, unless the contractor is notified in writing by the owner of the limits of authority of the owner's representative. It shall be understood that the authority of the latter to act for and on behalf of the owner is full and absolute. In the absence of a written communication by the owner to the contractor, the architect shall perform the functions and have the authority of the owner's representative if the project or work involves the construction of a building, but if the project or work involves the construction of an engineering structure other than a building or the construction of a building if such constitutes only a minor portion of the project, the engineer shall perform the function and have the authority of an owner's representative. So kung walang na-assign na representative yung owner, automatically yung architect ang magiging representative. Pero kung ang concern ay construction of engineering structures, ang engineer ang magiging representative ng owner sa project. The owner's representative shall also perform the function of construction manager unless the owner designates another person as construction manager. If the owner shall designate a construction manager and define his functions, those functions of a construction manager not delegated to the latter shall be performed by the owner's representative. Notwithstanding the designation by the owner of an architect, engineer, and/or construction manager, communications between the contractor and the owner shall be made only through the owner's representative. Ang owner's representative ay kung sino man ang nasa ng owner. Kapag wala ang owner, sa representative nakabase ang mga decisions. So, that's it.
Section 11, Schedule of Time Limits. Letter A is the contract time. When is the contract time reckoning? The contractor shall commence the work within 7 days from receipt of notice to proceed unless the notice or the contract provides for a later date. When shall the request for time be filed? The request for time shall be filed within 15 days from occurrence of event which caused the delay. Letter B is the contract sum. When should the breakdown of work and corresponding value be submitted? The breakdown of works and corresponding value should be submitted within 15 days from the receipt of the notice to proceed. When should notice be given to owner for claim for extra cost? The claim for extra cost should be submitted within 15 days after receipt of instruction involving extra cost or after recognition of delay due to owner's fault. Letter C. Progress and final payment. What is the period within which the owner should act on payment request? The owner should act on payment request within 30 days after receipt thereof. What is the period within which the owner should act on final payment request? The owner should act on final payment request within 30 days from the receipt thereof. When should interest accrue for delayed payment? By the owner. Delay in payment of the amount due shall entitle the contractor to interest from due date based on 30 days loan rate of the Land Bank of the Philippines. When should the retention be released? Not later than 60 days from substantial completion upon posting of contractor's guaranteed bond. Letter D. Substantial completion and its effects. When is there substantial completion? If the contractor completes 95% of the work or the owner approves contractor's billing for completing at least 95% of the work unless the owner can establish that the unfinished portion prevents the normal use of the completed portion. A contractor who substantially completes the work is not liable for liquidated damages, but only to damages representing the unaccomplished works. Is the date of the certificate of substantial completion or equivalent document controlling? No. If substantial completion is shown to have been attained earlier, unless the contractor accepts the certificate without taking any exceptions thereto in writing within 15 days from receipt of certificate. Letter E. Correction of work. When should the contractor receive the punch list? The owner shall issue the punch list, which the contractor must receive not later than 30 days from date of substantial completion. When can the owner add to the punch list items? The owner may add to the punch list items, but only as to the corrective work in the original punch list, not later than 60 days from substantial completion. What is the prescriptive period for the owner to correct, remove, replace poor or inferior work of the contractor? The owner has 1 year from date of final payment to condemn poor or inferior work. Otherwise, instructions to remove or replace such shall be treated as change order. When should defects be corrected by contractor? The contractor has 30 days from the receipt of the last item in the punch list to complete the corrective works. F. Contractor right to suspend work or terminate contract. What are the instances when a contractor suspend work or terminate contract? If any court or other authority orders the work to be stopped or suspended for 90 days through no fault of the contractor on his employees. The next one, if owner fails to pay contractors the approved request for payment within 30 days from receipt. If owners fails to pay contractor the agreed sum within 30 days after its award by arbitrators. If the owner suspends the work without just cause for more than 15 days without contractor's present or consent. The next one is if the owners fails to deliver at the construction site own supplied or furnished materials or equipment for work along the critical path beyond 15 days after its scheduled delivery date. And lastly, if approval of variation orders for additional works along the critical path is delayed beyond 15 days after submission for approval by the owner. Letter G. Owner's right to terminate contract. When can the owner immediately and without notice terminate the contract? If the contract should declare bankruptcy, become insolvent, or assigns his assets for the benefits of his creditors or appointment of trustee, receiver for the contractor, or any of its property. When can the owners terminate the contract after giving 15 days written notice to the contractor of his surety? If the contractor disregards or violates provision of contract, documents, or owner's instructions. The next one is fails to provide skilled superintendent, workmen, or sustainable materials or equipment. Next is fails to make prompt payment to subcontractors for labor or materials or equipment. Disregard the authority of the owner's representative, violates in any substantial way any provision of contractor documents. Lastly is repeatedly delays prosecution of works per agreed construction schedule and or PERT or CPM plus any time extension duly granted the contractor. Letter H is the disputes. When should the owner or his representative act on all matters under the contract? The owner or his representative shall act within a period of 15 days on all matters under the contract requiring the owner's approval, acceptance, or decision. What is the period which the contractor may submit to the adjudicator his disagreement with the determination made by the owner? If the contractor disagrees with the determination by the owner, or his representative, the same shall be submitted to an adjudicator to be jointly engaged within 15 days before the commencement of the work if either party disagrees with the resolution of the adjudicator, such as shall be deemed as dispute that may be submitted to arbitration. Letter I is the guarantee bond. When should the guarantee bond be furnished? Upon release of retention. How long will it be effective? 1 year commencing from the date of acceptance as guarantee that all materials and workmanship installed are good quality.